Ujjwal Kumar Kalla to kindly deliver today's lecture. Thank you, sir.
Thank you. Thank you. My screen is visible to all the participants. My screen is visible. Am I audible?
Yes, sir, you are audible.
Yes, sir.
Okay. See, patent filing and commercialization. Now it is very important for all the people working in the area of engineering, technology, in the startups, in companies. Okay, so this topic is relevant for everybody. Usually, writing is very relevant to the people who are actively involved in the research area, means who are professors or guiding research or who are teaching and for the research scholars. But as far as patent filing, patent writing, commercialization procedure for the patent are equally useful to the industry people also. Okay. So, good evening to everybody. Today we will explore the fundamental roadmap of patent filing and commercialization in India. So understanding of this procedure is equally important for everyone. Okay, and this is critical to understand. It is critical to transform your abstract idea into a valuable, commercially valuable and legally protected assets. The bedrock of this patent act, patent procedure in India is the Indian Patent Act of 1970, assigned with the patent rules of 2003, and regulatory body or administrative body for this complete procedure in India is the Controller General of Patents, Design and Trademarks. Okay. See, the patent is a territorial right. Okay. So patent is a territorial right. Okay. So if the patent is granted in India, it will provide protection to your innovation in within the border of the India. If you want to get the protection in some other country, then you have to apply the patent in that country also. Suppose if you want to protect your invention in Pakistan, so you have to get Pakistani patent. If you want to protect your innovation in Bangladesh, so separately you have to apply for filing patent for the same invention in Bangladesh. So like that, in every country, wherever you feel that you want to protect your innovation in that particular country, you have to apply as per the norms of their country. Every country has different patent acts. Okay. So there is no thing like universal patent. Okay. So no one can get the universal patent which is applicable to in all the countries. Okay. So this is a territorial right. Okay. But once the patent is granted, it will give you the monopoly of exactly 20 years from the date of filing. And it will allow you to stop the others from using your technology, from making that product. Okay. And the validity for the patent is exactly 20 years from the date of filing, not from the date of grant. Okay, the date of filing is called priority date. In the patent field, the date of filing is called priority date, and it will be considered from the day you have filed the provisional patent. Okay, the day you will file the provisional patent or complete specification, that date will call priority date. Okay, so you may start with the provisional patent as well as you may also start with the complete filing directly. Okay, so even if you apply for the provisional patent application, the date of filing of provisional patent application will be the date of priority. Okay, so and the 20 years will be considered, will be counted from the date of filing of that patent. Okay. See, not everything, not every good idea is patentable. Okay. If anything, if you have in mind, that may not be patented. Okay. So as per the Indian Patent Act of 1970, uh, to be patentable under section 2, subsection 1, clause J of the Indian Patent Act, an invention must satisfy three strict criteria. First criteria is the novelty. Okay. Novelty means it should be completely new, and it should not be available anywhere in the public domain, and it should not also be available in any universal literature. Okay. So the idea, whatever you are going to get patent, should not be available anywhere in the public domain, as well as it should also not be available in any universal uh, literature. Okay. So if the idea is mentioned in some books or in some website, okay, in any research paper, so if it is disclosed, okay, you may not uh,
ये सारे कॉम्प्लेक्स लेने विदाउट भर के
after that, if that okay, so जिस भी दिन आप पेटेंट फाइल करते हैं, उससे पहले उस बात को डिस्क्लोज किसी को नहीं करना है. ओके. Second critical criteria, strict criteria, which is required for the grant of patent, is inventive step. It is really very difficult. Okay. Most that okay. So if okay, so mere create okay. Why not in India. Or but instructions you to control idea that or mathematics is being used to control physical and system.
Hello, sir. Excuse me, sir. Ujjwal, sir. Hello. Excuse me, Ujjwal, sir. This is Arvind. Hello. Sir, your voice is breaking, sir. Can you take good in rejoin or take proper internet, sir? Your
Okay,
sound
okay.
is.
Am I audible now?
Now it is audible, sir. It is perfect audible, sir. Now. Yeah, PPT
Okay,
is
okay.
also not visible, sir. Can you reshare, sir?
Huh? Yeah. Please,
Yes,
please.
yes.
Let me check.
Ji, sir. Now your sound is coming perfectly, sir.
Screen is not visible?
No. Screen is
Screen is visible?
not coming, sir. You can reshare, sir. Just
Okay. Let me share. No.
share option is there. No, just
Yeah. Please.
sir.
Is my screen is visible now? Is it visible now?
Sir. It is visible. Screen is visible, sir. Yes, sir.
Okay. May I continue now?
PPT is also, sir, coming. Yes, sir.
Okay, that's
Yeah.
fine.
Thank
That's
you. Yeah,
fine.
thank you.
इससे पिछली पीपीटी आपको क्लियर हो गया था या उसको रिपीट करूं? The core requirement for the patentability. Do you want me to repeat it?
Yes, sir. Yes, sir.
Okay.
Yeah.
So the core requirement for the patentability is the three basic strict criteria which are required in India for the grant of patent as per the Indian Patent Act of 1970 under Section 2, Subsection 1 and Clause J of the Indian Patent Act. The first criteria is novelty. Novelty means the invention must be completely new and it should not be available in public domain or in any universal literature. Means it should not be published in any book, it should not be published in any journal or any other document. Okay, and it should not be in use in any industry or in any part of the world, not only in India. Okay, not only in India, it should not be in use in the public domain all over the world. Okay, and it should not be also reported in any international document or national document or in any local document. So that is novelty. Novelty means new. Okay, so something which is new is called novel. So by visiting the prior arts websites, you can establish the novelty of your claim. Okay. Second is inventive step. inventive step, that is more important. Okay. So sometimes you may have a new idea, means you may have a novel idea, but it must have some inventive step. Inventive step means, this means solution should be non-obvious to a person skilled in the art. Okay. Skilled in the art means a person expert in some specific field. Suppose if there is a invention in the area of power electronics, so the person who is having a good PhD and having some publications and patents in that area, if he said that this scheme is non-obvious, then it will be considered that then you can establish the inventive step of that patent. Okay. So third point is the industrial application. So merely theoretical idea in India is not patentable. So your idea, your technology must have some inventive, so some industrial application. Okay, and it should be capable of being manufacturing or being used in the industry somewhere. Okay, so am I audible to all of you now?
Yes, yes, sir.
Okay, okay. So next point is the non-patentability subject matter. Non-patentable subject matter means statutory exclusions. Okay. So Indian Parliament has explicitly excluded certain category of the patent technology under Section 3 and Section 4 of the Indian Patent Act. So under Section 3, the minor tweak an existing medicine is not patentable. Minor tweak to an existing medicine is not patentable, and that is done by the government of India in interest of the public. Okay. To protect the public from the evergreening of the drugs. So usually what medicine companies, pharma companies do, they get patent on some medicine. Okay. So suppose they have made a tablet for a fever. Okay. And after 20 years or 19 years, they will file another patent that now we have got this technology in form of syrup also. Okay. So that therefore it can be used for the children's also. So please grant us the new patent on the same technology. So definitely for 20 years, they will also get the patent. But as per the Indian patent law and Section 3 of the Indian patent law, this such type of minor tweak to an existing medicine is not patentable. Okay. थोड़ा बहुत बदलाव करके आपको you have to make some substantial improvement in the existing technology. Okay. So by making some form of by changing form of some substance, you may not get patent. Okay. Second point, which is very much important for the research community from the software side or computer side, it is very important to understand that software per se and business model or business methods are not patentable in India. Software per se is not patentable, and business models or methods are not patentable in India. Computer program per se is a Latin word. Okay. Per se means in isolation. So computer program, computer algorithms in isolation are not patentable, but if that algorithm is being used to control some physical device. Okay. Suppose if I have a algorithm or program which is which is being used for control of my electric car. Okay. Then it is patentable. So then that algorithm will become process. Okay. So process and product. Okay. Both are patentable in India, means system and method. Both are patentable. System means complete car system. Okay. And method. So algorithm becomes method if that is being used to control some physical device. Okay. So, but the computer code in separation, in isolation, computer instruction set in isolation is not patentable unless and until that is not being used for the control of some physical device. Okay. So that is called that is all about the computer software point of view. So if you have any further, if you want any further clarification, you can ask me after completion of this lecture. Okay. So, and third is the traditional knowledge. Okay. So traditional knowledge, something which is already known to the traditional community, may not be patentable in India. So direct aggregation or modification of traditional community knowledge is also not patentable in India. Means discoveries are not patentable. Inventions are patentable, but discovery means something which is already existing in the nature, and I have disclosed that thing. So that is called discovery. Okay, and invention, that is which is something exactly new, totally new. That is called invention. So inventions are patentable, but discoveries are not patentable in India. And inventions related to atomic energy are outrightly rejected for the patenting. So Indian Patent Act doesn't allow any technology which is related to the atomic energy. So even if you will write this word in your patent document, patent energy, so it will be difficult for you to get it granted, because of Government of India may transfer that patent application to BARC like organization. So they will especially examine your application. So you should try to avoid uh, 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 writing such words in your patent application. So software per se is a legal and technical phrase that means software by itself or software in itself. It refers to a standalone computer code, standalone algorithm, or set of instructions existing in isolation, completely separate from any physical device. So this terms comes from the Latin language. Okay, and I said that discovery is also not patentable in India. Only inventions are patentable. Invention means creating something new that did not existing that did not exist before. Okay, but discovery, finding something that already exists in the nature. Okay, so that is patentable. Okay, like finding a wild plant in with natural healing properties. Okay, कोई ऐसा पौधा है जिसको का पत्ती को खाया बुखार ठीक हो जाता है. Okay, so if someone will discover such a plant that कि इसकी पत्ती को खाइए आपका बुखार ठीक हो रहा है, तो please grant me a patent. So the patent will not be granted in such situation because of that is discovery, that is not an invention. Okay. Now the pathway to file a patent application. So there are two different pathways for filing an Indian patent application. One is through provisional application. Okay, through provisional application means if your invention is still in development, okay, and you want to secure an early priority date, okay, so then you should go for filing the provisional patent application, okay, and that is valid for 12 months. Okay, so आपके पास कोई आइडिया है जिसके बारे में आपको ज्यादा नहीं पता है, अभी तक आपने उसको पूरा नहीं किया है, पर आपको लगता है काफी नोवेल है, इनोवेटिव है, इसका बहुत इंडस्ट्रियल एप्लीकेशन होगा. ओके, सो देन यू शुड, बट यू वांट टू चेक विद द मार्केट. ओके, सपोज if you want to check with the market कि मेरा ये बिकेगा या नहीं बिकेगा, whether the industry people will accept your idea or not, so whether you should invest your money in the patent filing process or not. Okay, so some people even if they have a complete technology ready for filing complete specification, but they don't file complete specification, they go for provisional application, because the provisional application also give you a priority date. Okay, it will give the full protection to your invention. Or after filing provisional application, you have a 1 year time, okay, to decide to check with the market. Okay, then go to the market and check and discuss with the stakeholder in that area, means to different industry people and other people working in that area. If some industry or any person is interested in licensing of the technology, then that person may go for the complete specification filing. Otherwise, he will withdraw that patent application after 12 months. So he can save his money. Okay. And second, in some cases, they definitely want to file a complete specification, complete application, but they don't know exactly what could be the claims for that invention. So in patent filing, most important thing is the claims. Claims decide the legal boundaries of your invention. Okay. ऐसा नहीं है मैंने कोई इन्वेंशन किया इलेक्ट्रिक कार से रिलेटेड है, ओके। सो it doesn't mean that if I have a patent on electric car, so all the concept and all the things related to the electric car will be covered by my claim, okay. So I may have some specific claim, so every claim has some legal boundaries, okay. So unless and until I don't know exact legal boundaries of my claim, I should not go for the complete specification or complete application filing for the patent. Okay. So what is major difference between the provisional application and complete application is, in complete specification filing, you have to disclose the claims of your patent. Okay. So claims are legal boundaries of your invention. Okay. So that are really very important. So if still if you are मेरे को हाँ गौरव जल्दी बताओ मैं मीटिंग में हूँ बताओ मैं तुम्हारे Am I audible?
Yeah,
Hello.
you are audible.
Am I audible?
Yes, sir, you are audible, sir.
Okay, okay. Screen is also visible. No?
Yes, sir, you are audible.
Sorry for the disturbance. So we have two pathways: provisional application and complete application. Okay. So but your patent will go for examination only after filing a complete application. Okay. And if the boundaries of your claims, legal boundaries of your claims are very clear and technology is fully developed, okay, and you are very much sure that you are going to get a complete claim. So in that case, instead of filing provisional application, we should directly go for complete application filing for the Indian patent. So a provisional patent application is a temporary application. That is not a complete patent application. Okay. That it gives you a 12-month to test the market before filing a regular patent. Okay. Means complete specification. Complete application is called regular patent filing, and provisional is a temporary application. Okay. So while it does not require formal patent claims, the provisional patent filing does not require formal patent claims. It must fully describe the invention so someone skilled in the art can understand it. Okay. So if you are going to file a provisional application, your technical description and objectives of your patent application should be very much clear, so that a person skilled in the art can clearly understand your technology. मीन्स आपने जो कुछ भी टेक्नोलॉजी क्लेम करने जा रहे हैं आपको उसको पूरा क्लियरली उसको उसमें एक्सप्लेन करना होगा, अदरवाइज योर प्रोविजनल एप्लीकेशन विल नॉट बी एक्सेप्टेड. Okay, so the objective, mainly the objective of your invention should be very much clear, and the technical details should be clearly explain all the technical things related to that invention, so that a person skilled in the art can understand that technology fully. So the required technical detail in the provisional applications are as follows. The title of the invention is required. Okay, field of the invention is also required. While we are filing this provisional patent application, we have to write the title of the invention, field of the invention, background and object of the invention. Object means objective of the invention. Background means prior art, comparison of your invention with the prior art. Okay. So that is the brief explanation of the existing technology of prior art, and its disadvantage and hello.
Sir, you are not audible.
Okay. Am I audible now?
Yes, sir.
Okay. Okay. Sorry, we have some problem in this connectivity because of our departments are being shifted from one building to new buildings. Okay. So because of that, we have some technical issues in our department. So because of our department is being shifted to another building. Okay. So sorry for that. Now, am I audible to now? No.
Yes.
So that is I am confirming in between also. So are you clear about the provisional patents and complete specifications?
Yes.
Okay. So now the main requirement for drafting a complete patent application in India are a fully disclosed description of invention, at least one definitive claim and an abstract. So you have to have one definitive claim. So if you are going to file a patent for your invention, you should have at least one claim. Okay, number of claim may be 2, 3, 4, 5. Okay, or usually it should not be more than 10 or 15. Okay, so usually maximum number of claims are 10. If you will increase the number of claims, you have to pay extra fee for that. Okay. And the complete specification must be drafted with high technical and legal precision to ensure the patent enforceable. Suppose if you have written complete specification of patent, that is, the patent is also granted to you. But sometimes, if that patent application is not fully described, the patent will not be enforceable. Okay. So, in order to make your patent, granted patent, clearly enforceable, you should draft your technical document with very much clarity, okay, and high technical and legal precision, okay. And technical specification or complete filing of your, complete specification or complete filing of the patent application should include title of invention, field of invention, background of invention, objectives of invention, statement of invention, summary of invention, brief description of drawings, detailed descriptions, okay, and claims, okay. Remaining things may be same, but the claims and abstracts are additionally added in the while we file the complete specification. Okay. And then now type of the patent application. So there are three type of patent application: ordinary patent application, convention application, and PCT, national phase application. We always file the ordinary application. Okay, whenever we file the patent application, that is called ordinary application. That is standard filing without claiming any priority from previous application. Means जिस डेट को आप फाइल कर रहे हो उसी दिन से ही उसका प्रायोरिटी डेट माना जाएगा, यानी पेटेंट विल बी कंसीडर्ड फ्रॉम द डेट ऑफ फाइलिंग ओनली. ओके, बट सपोज इफ आई एम फाइलिंग ए पेटेंट in India on 20th of June. Okay, but if I have already filed that patent in France on 1st of June. Okay, 20 days back. So in that case, I will file my application as a convention application. I will file as a convention application. Convention country के अंदर. So there is convention countries which are 121 member states. Okay, means 181 countries are member in the Paris Convention. Okay, so all the members have decided that if a patent will be filed in one country, Okay, so the date of priority allotted in that country will be applicable in all the 181 countries in the world. Okay, suppose if I have filed a patent in France on 1st of June and I have filed the same patent in India on 20th of June, then the priority will be considered from the 1st of June. So then what is the advantage of that? Because of if someone has disclosed that technology on 10th of June, okay, I will get patent because of my priority date is 1st of June. Okay. So it should not be disclosed before 1st of June. Okay. So the priority date of patent may be different than the date of filing if it is already filed in some convention country. Okay. Convention country, Paris Convention countries. Okay. But that should be within the 12 months. Okay. So if I have filed the patent in 1st of June in France, I must apply before the completion of 12 months from that date in any Paris Convention countries. Okay. For getting the advantage of priority date of 1st of June. And third is PCT, National Phase Application. Okay. So uh, it should be filed within 31 months from the international priority date via the Patent Corporation Treaty Framework. Okay. So if someone want to file a patent application in number of countries, then he should go for the PCT application. Okay. But it will cost high. So the Paris Convention countries are the 181 that are signatories to the Paris Convention for the protection of intellectual property and international treaty governing intellectual property, patents, trademark, and industrial designs. The convention grant creates the ability to claim property across borders, meaning filing in one member country establishes a filing date that is recognized by all other convention countries. Now the PCT is an international treaty administered by the World Intellectual Property Organization, WIPO. Okay, and this is a unified system. It provides a single streamlined procedure for filing patent application in up to 155 member countries simultaneously. And what is not covered in this? There is no such thing such as an international patent, and patents are always granted by individual nation or regional patent offices. Okay. And the primary benefit for going through the PCT route is it buys the application time up to 31 months or 30 months to decide which specific countries are worth the investment. Like suppose if once you file the PCT, you can decide कि अब मुझे किस किस कंट्री में और फाइल करना है. आप एक बार पीसीटी फाइल कर दीजिए, इंडिया में फाइल कर दीजिए, अदरवाइज तो 12 मंथ में एक्सपायर हो जाएगा, है ना. पर आप चाहते हो कि वो 2.5 साल तक आप किसी भी पेटेंट में फाइल कर पाओ किसी भी कंट्री में, देन यू हैव टू गो थ्रू विद द PCT route. Okay, that will give you the flexibility up to 30 months. Okay, for filing international patent in any country. By that time you can decide, okay, which specific countries are worth the investment for filing patent. Okay, am I audible?
Yes, sir.
Okay.
Yes, sir.
Yes,
Now
sir.
the trade. Pardon? Pardon, sir? Hello.
Audible, sir. Audible.
Okay. Okay. Now the traditional Paris Convention versus PCT path. The Paris Convention route require separate individual filing in each target country within 12 months of the initial home filing. Okay, and demands immediate high cost. Okay, but through PCT route, a single international application filed within 12 months of the initial home filing. Okay, and that postponed foreign national phase cost by an additional 18 months, allowing the market and financial evolution. And these are the key strategies, key strategic advantages of filing PCT. It provides you financial flexibility, available intelligence, single unified format, and amendment power. Okay, so applicant can amend their claims universally during the international phase to fix flaws before the foreign examiner review the file. So India uses a first to file system. India uses a first to file system, means the person who files first get the right, not the person who create it first. किसी आदमी ने कोई इन्वेंशन किया है पर उसने किसी को बता दिया और उसने जाके पेटेंट फाइल कर दिया, तो जो फाइल कर देगा वो पेटेंट उसको ग्रांट होगा, बिकॉज ऑफ इंडिया यूजेस फर्स्ट टू फाइल सिस्टम. ओके, जो भी आदमी पहले जाके फाइल कर देगा, सो देयरफॉर यू शुड नॉट डिस्क्लोज योर इन्वेंशन टू एनीबॉडी एक्सेप्ट यू. ओके, so otherwise if he will file patent before you, okay, so he will become first to file, so the patent will be granted to him. Okay, and now we will discuss the step by step patent procedure. Okay, the first is patentability search. So if you have any novel idea, then you should do the patentability search. Okay, so you should search the similar technology on Google Patents, in Indian patent website, European Union patents, Japanese patents, Chinese patent, US patents. Okay, so we should search on all the websites, okay, for the same technology in order to establish the novelty of that patent. Okay, so once you become confirmed that my patent, my invention is completely new and it is not available in any public literature or in public domain, so then we should come to the second point, that is drafting specification. Okay, drafting specification is formatting the technical details in form number 2. Okay, form number 2 एक होता है, उसमें सारा डिटेल लिखा जाता है, that is called complete specification form. Okay, form number 2, that is main form of patent. So all the claims, all the technical detail, everything, all objective, all diagrams, flow chart, okay, all drawings are mentioned in that form number 2. So the main application of patent is form number 2 as per Patent Act. Okay, and it is submitted with the form number 1. Okay, so form number 1 is a formal application for filing patent. Okay, then filing application, then we have to submit the required statutory forms like form number 1, 2, 5, 8, whatever the requirements we have to fulfill that, and we should submit all these forms, and then the patent will be published within the 18 months. Okay, sorry, after 18 months it will be published, after 18 months. But if you will apply for early publication, then your patent will be published in 1 month time. Okay, so you have to pay more for that. Okay, for early publication. So if you want to get it published within 1 or 2 months, then go for early publication route. You have to pay some fee for that. Okay, otherwise it will be automatically published after 18 months. Okay, in the Journal of the Patent Office. Okay, and then Gazette of the Patent Office, and once it will be published, we have to submit the examination report request. Okay, so even with the filing of patent on the first day of filing, we may also submit the examination request along with the form number 1 and 2 also. Okay, so we have, see, publication is automatic. If I will file a patent, it will be published automatically. Okay, but examination is not automatic. Okay, if you want to get it examined, you have to apply for the examination. Okay, within 4 years of filing the patent, means within 48 months of filing patent, we have to apply for the examination. Once we will apply for the examination of that patent, it will be come into the queue of the patent. Okay, so whenever your number will come, and first examination report will be issued by the patent office, and examiner needs to respond that first examination report. So first examination response to the first examination report should be submitted within 6 months from the date of issue of the first examination report. Okay, after 6 months your patent will expire. Okay, abandon. Okay, although you may get extension in that for further 3 months by submitting some application and paying some fee, but after that it will be abandoned. Okay, and once you submit the response to your first examination report, patent office may directly grant the patent, or they may also call for the hearing. Okay, the patent office may also call for the second examination report, third examination report. Okay, like that, patent office can also go for first hearing, second hearing, third hearings. Okay, so they may call for hearing any number of times. Okay, after hearing, inventors are supposed to submit the post hearing submissions. हियरिंग के टाइम में हम जो बात कहते हैं ना, नहीं ऐसे नहीं, ऐसे है, ऐसे नहीं, ऐसे है, वो सबको हम एक पोस्ट हियरिंग सबमिशन, एक डॉक्यूमेंट होता है, उसमें लिख के देते हैं कि हमने जो बात हियरिंग के ड्यूरिंग वर्बली कही थी, उसको राइटिंग में हम सबमिट करते हैं, उसको करते हैं. दैट इज कॉल्ड पोस्ट हियरिंग सबमिशंस. ओके, so once we submit the post hearing submissions, patent office may again call for the hearing, or they will grant the patent to you. Okay, and once it is granted, you will get the legal monopoly of exactly 20 years from the filing or priority date. Okay, and these are the mandatory forms and disclosures. So whenever we file the Indian patent, we must file form number 1 and 2. Okay, these two are the mandatory forms. Form number 1 आपको file करना ही है. Okay, and it is a general application for the grant. Okay, okay, and form number 2 is the original or complete specification. Form number 2 is the complete. So form number 2 includes the complete specification document containing description, drawings, claim, abstract, patent specification document, all technical descriptions, abstracts, legal claims, okay, drawings, technical detailed description, all everything is included in form number 2. And form number 3 is not mandatory, is not required to mandatorily file, because of it require in some cases. Okay, so it is mandatory update on corresponding the patent application filed in foreign nation. Okay, so sorry, we also have to submit the form number 3, and this is the statement and undertaking regarding the foreign application. So in this form we will disclose if we have filed the same application in any other country. Okay, so in that case we have to mention that in the form number 3. If we have already filed that patent application in any other country other than India, that thing we will mention in form number 3. And form number 5, that is very important. So the declaration of the true and first inventorship by the inventors is included in form number 5. Means through form number 5, inventors claims that we are the first and true inventor, and we are assigning this technology to our employer or applicant. Okay, so the legal right will be held by the applicant. Okay, so if inventor may also be applicant, or if inventor himself is an applicant, then all the legal right will vest into the inventor only. If inventor is not applicant, then he will decide who will be the applicant. Suppose you say MNIT Allahabad is the applicant and we 3 are the true inventor. So all these things will be mentioned in form number 5 of the patent. Okay. Then form number 9 is for the request for early publication. If you want to get it published within 1 or 2 months, then you have to submit form number 9. Okay, am I audible? Am I audible?
Yes, sir.
Yes, sir. Audible.
Audible, sir.
Okay,
Audible.
sorry. Actually, I had doubt on the connection. So form number 18 or 18A, okay, that is the request for examination. Okay, so form number 18 is the request for examination in routine. Okay, so but if you want a fast track examination, then you have to go for expedite examination. So if you will go for expedite examination, you will get the first examination report within the 5-6 months or within a year. Or if you will go for ordinary examination, it may take 2 years, 3 years, 4 years, 5 years, 6 years, 7 years, depending on the system. And there is form number 26, that is power of attorney. If anyone else means any patent agent or any IPR firm is filing patent on your behalf, then you also need to submit the form number 26. Okay. Now, the publication and examination stage. Okay. Once you will file, your patent will be published. Publication is automatic. Okay. After 18 months. But if you have also filed form number 9 for early publications, your patent application will become public within 1 or 2 months. Okay. But if you have submitted application through ordinary patent filing examination route, your examination will take a lot of time. But if you want to apply for the through expedite examination, you have to submit form number 18A and 8,000 rupee fee for that. But not all the applicants are allowed to file process their patent through expedite examination, because of only the patent who are having the women co-inventors, women co-applicants, and the patents of startups, patents of government departments, okay, government organizations. These are only the MSME forms, okay, MSME small entities, okay. These are only the 4 member eligible for filing expedite examination, okay. So for the government organization or women individual inventors, we need to submit 8,000 rupees fee. For the large entities, they have to pay 60,000 rupees for the same. Okay. And then request for examination that we have already discussed. And you need to submit the response to the first examination report within the 6 months of the issue of first examination report. Okay. Now, application may be further classified into ordinary application, division application, or convention application. Okay. So ordinary applications filed directly in India as a new standalone application, okay, to protect a single invention from the scratch natively in India. Okay. But divisional application is filed to split out from existing parent application in India, okay, to separate multiple invention originally combined in one patent application. In case if you want to report number of invention in one patent application which are not exactly technically related with each other, then you have to go for the divisional application filing for that patent. Okay, means एक कार है, उसके अलग अलग पार्ट्स के अंदर आप कुछ इन्वेंशन क्लेम कर रहे हो, तो अगर टायर का कोई कंट्रोल है और साइड मिरर का कोई कंट्रोल है, उनका टायर का उससे कोई कंसर्न नहीं है, तो इन दैट केस ड्यूरिंग द एग्जामिनेशन controller may ask you to file this divisional application, okay, to split out from an existing patent application. And third is the conventional application. Based on the earlier foreign application in Paris Convention country, you may go for convention application, okay, to claim the earlier filing date of the foreign application in India for taking the benefit of the priority date. Okay. So divisional applications are filed under section 16, okay, and conventional applications are filed under 135 of the Indian Patent Act of 1970. And the critical action timeline is the you need to submit the request for examination in ordinary cases after 18 months, okay, and for early publication, you have to submit immediately the form number 9, okay, and you need to you need to submit the request for examination within the 18 months, 48 months, okay, okay, almost, okay, but here we have mentioned within 31 months of the prior, no, so you need to submit the request for examination within the 48 months, okay, otherwise the application deems to withdraw, okay. and the response to the first examination report should be submitted within the 6 months. And additionally, you may take the extension for 3 months by submitting some fee through an application. Otherwise, after that, the application will be abandoned. Okay. So post grant opposition filing within 12 months of the grant application, the right to challenge the IPO expire after 12 months. Okay. If once the patent is filed, you can challenge that patent only up to 12 months. So once it is granted, and after 12 months means after 1 year, you may not challenge. Never you can challenge that patent. Okay. And that is the step by step fee prosecution fee for filing patent. For e-filing, you will get 10% discount on all the fees. Okay. For form number 1, fee is 1600. Okay. And for early publication, you need to pay 2500 rupees. Okay. And for ordinary publication, you need not to pay anything. Okay. And for standard request for examination, you need to pay 4000. And for expedited examination, you need to pay 8000. Okay. And once the patent is granted, in order to maintain that patent, you have to pay renewal fee. Okay. So for initial 2 years, you need not to pay any renewal fees. For 3 to 6 years, you need to pay 800 rupees per year. For maintaining the same patent from 7 years to 10 years, you need to pay 2400 rupees per year. Okay. And for 11 to 15 years, you need to pay 4800 rupees per year. And for 16 to 20 years, you need to pay 8,000 rupees per year. Okay. So as the number of years will increase, the renewal fee increase substantially. Okay. So if your patent is not being licensed, so people don't pay renew fee after 10 years. Okay. So now the time to conclude this presentation. So timeline really matter. So missing the deadlines like 12 months specification window or आया 6 महीने तक रिप्लाई नहीं किया, अच्छा चल जाएगा, and your drafting strategy. Okay. And legally it should be safe, right? Okay. So your drafting must be able of saving your claims legally. Okay. So drafting should be good. Okay. So you should take care of the claims, and you should read the claims in detail. Okay. And the claim made in should be technically viable. ऐसा बात नहीं होना चाहिए जो technically हो ही नहीं सकती. उसको क्लेम अगर ग्रांट भी हो गया तो आपको फायदा नहीं होगा उससे, क्योंकि वो हो तो सकता ही नहीं है. Okay. And the commercialization power. A successfully granted patent offers massive competitive leverage and license opportunity up to 20. Okay. Thank you. So now the session is open for the query. Am I audible? Am I audible, sir?
Yes, sir. Yes.
Okay. So now the session is open for query. So if any participants have any query regarding patent filing, commercialization, you may ask me. If any question, if you have in your mind. No question. No
Yeah,
query?
any participant
Pardon?
who are interested to ask any questions or any other doubts, ask sir. Sir is having wide experience.
Hello.
Yeah.
Hello, sir.
Yeah.
Sir, this side Rahul Kumar from NIT Allahabad.
Okay.
Sir, my question is that suppose there are two people who got the patent license of one product. So in
Okay.
future, who can claim the object of
No,
which
no,
they
that is practically not possible. Who will get the patent first will be eligible for that, eligible candidate for the same. Okay. So anyone who will file first will get the patent. Okay.
Yes, sir.
Hello.
Like
So
earlier,
patent
at
office
first.
will do the prior art search. They will also examine if already if anyone else has also got the claim, they will check. Then only they will grant you the patent. Okay. So the patents right will be given to the person who has filed first in India. All the rights.
So, sir, is it specifically limited to the individual or any group, like an organization?
Can you repeat your question?
Sir, I'm asking that is it specifically limited to the individual or any organization?
Maybe assigned. Actually, your sound means you are asking that individual may also be applicant or only organization. Is it?
Yes, sir.
Means if you are a true inventor of that technology, that is your right. You may assign that technology to any other applicant or any organization or anybody else, okay, or to your employer, or you may also file as an applicant. But as far as the central government policy or NIT policies, so NIT employees may not file patents in their name unless and until they don't get permission from their employer. Okay, so in that case, we have to mandatorily assign the patent application to your employer only. That depends on your IPR policy of your organization. But if you have no IPR policy and your employer is allowing you to file patent as an applicant, definitely you can file, but you should take that approval in advance from your department if you are working with the government organization. Are you agree with me?
Yes, sir. Thank you, sir.
Is it clear? Okay. Anyone else?
Hello, sir. Sir, is it
Yeah.
possible to share PPT today's presentation slides so that we can go through it and if you have any doubts, can we contact you through email?
No, this is all these things are already mentioned in the Indian Patent of 1970. Everything is there in the Patent Act 1970. I have taken from that only. So just you can refer the Patent Act 1970 and Patent Rules of 2003. Just you write that on Google, everything will come. Now, these are not my claims. That is not, and these are not authored by me. Just I am explaining the whatever it has been mentioned in the patents, and I have experience of many years, almost 20 years. I have filed my first patent in 2008-9 with IIT Delhi. So I have the vast experience in this area. I have appeared in many hearings, so I understand this procedure very well. But everything is already there in the Indian patent. We also refer that only whenever we have any confusion in this regard. Even then, if you have any query, you can send me the mail. I will reply.
Hello.
Yeah.
Sir, can we publish the same idea in any journal as well as file a patent simultaneously?
Yes. This is a very good question. Definitely, you can do that. But first, you have to file at least provisional patent for the same technology. the day you file the provisional application for the same technology, very next day you can communicate your paper. But your paper should not be in public domain before your date of filing. Are you getting my point?
Okay, so yes, sir. But can the same thing should be communicated as a journal paper, which we have filed as a patent? The same idea, same product can be communicated.
Definitely, exactly
Okay.
same you can do. Exactly same, no issue.
Okay.
You can get the patent and
Okay,
paper
thank you.
both for the same thing.
Okay. Okay.
But
Thank you.
file patent first, then go for publication.
Okay. Okay. Thank you, sir.
Okay. Yeah. Anyone else? Anyone else?
Yes, anyone else is having any doubts? Okay, so I think no one is having doubts, sir. So I'm concluding the session. So Sunil, are you here? Okay.
Yes, sir.
So yeah, you can conclude.
Thank you very much, Professor Dr. Ujjwal Kumar Kalla sir, for delivering such an enlightening and engaging lecture. Your valuable insights, practical experience, and thoughtful discussion have greatly enriched our understanding of the topic. I'm confident that all the participants have benefited immensely from your expert guidance. We sincerely appreciate the time and effort you have devoted to the session despite your busy schedule. On behalf of organizing committee of ROTW 2026 and all the participants, I express our heartfelt gratitude to you. Once again, thank you very much, sir. Thank you, everyone.
So thank you. We can close the session, sir. So
okay, may I leave now?
Yeah. Yes, sir. Yes, sir. I will share some files to you, sir. So please
Sure.
feel your convenient. You can revert back, sir.
Please, please, please. Thank you. Thank you so much.
Yeah, thank you so much. Thank you, everyone. Now we will start another session at exact 5 p.m. So all are requested to join at 5 p.m. for another session, which will be handled by Dr. Mohan Bansal from IIIT Sonipat. So once again, thank you, everyone.
Thank you.